So, thank you for coming to this, one of the last press briefings of the AGM, and this is on regulatory issues, and I'm delighted to be joined by Leslie Macintosh, who's our Corporate Secretary and Acting General Counsel, and amongst her many hats, she also looks after a lot of our regulatory affairs advocacy, and that's going to be the topic we're going to talk about today. Over to you, Leslie.
Good morning, everyone, and I want to talk about a few key regulatory issues that are facing the industry. And I also want to talk about those issues and have a little bit of a discussion about the context of dealing with those issues with the ICAO Assembly coming up this year. So I want to do that. And I also want to say that, regulatory affairs sounds very dry, but it is very exciting, and there are some very hot and moving topics going on right now on this. And I'm hoping this next slide and our next discussion will kind of get you interested in it. Because, it's the broken jigsaw of regulation, but what does that mean? And why is that important to member airlines? And for me, it starts back to the kind of philosophical founding principles of regulation in aviation. And that's, of course, the Chicago Convention and the framework that surrounds the Chicago Convention. And that framework, is it broken? Is it part of this broken jigsaw when we think about regulation that is not part of the Chicago framework, but maybe should be, perhaps, or at least aspects of it should be? Because just to refresh everyone's memory, the Chicago Convention framework recognized the need for states immediately following the war, the Second World War, to avoid adopting unilateral and extraterritorial measures that may affect the orderly, sustainable, and harmonious development of international air transport, and ultimately to ensure that domestic policies and legislation are not applied to international air transport without taking due account of its special characteristics. So, why am I raising this very pithy, interesting to me, but maybe not to many others, historical fact? Because when we think about the growth of regulations in the years after that, and most recently in the years, last 15 years or so, this is where things like consumer regulations, data protection regulations have grown. And they are something that have happened independently of any considerations of the special characteristics of civil aviation, with one exception, of course. Consumer regulation for aviation is, of course, targeted at aviation. So what are our concerns? Our concerns are a number of them. It's like thinking about this jigsaw where different states make regulations for their jurisdictions, for their citizens, and how they fit together in a framework when you are traveling or goods are traveling across various jurisdictions. So if you think about it, when you flew here from wherever you came from in the world, and let's say you were delayed, which consumer protection regime would apply to that delay? Would it be where you came from? If you traveled through the EU, would it be the EU GDPR, EU 261? Or if you came from Canada, would it be the Canadian APPR? Or would it be the Indian regulation, because that's where you landed at the end? So which regulation applied? The same issue, and that's why I tripped up a bit by saying EU GDPR almost for a moment. If you had a data issue, so the airline was required to provide sensitive personal data maybe to the Indian police. I think we probably experienced that a bit yesterday when we had to provide that data. So which privacy law governs the provision of that data? Is it your national data privacy laws? Is it where you were traveling, if the airline is the one who provided it, or is it Indian? So it's this conundrum and inconsistencies or variations in legislation that really is key to both the data privacy issues and the consumer regulation issues that we're going to talk about today, and that we are going to talk about in the context of the ICAO Assembly as well. So just a reminder, and moving on to focus on consumer protection and passenger rights. In 2013, IATA adopted, core principles on consumer protection, and ICAO in turn adopted its own core principles following the 38th Assembly. In the 10 years or so since then, a number of new challenges have emerged, including the growing cost of consumer regulation, extraterritorial application, confusion over what is and what is not within the airline's control, particularly with delay, mass disruption events such as COVID-19 and CrowdStrike that have highlighted the lack of shared responsibility, and the emergence of claim farms that handle the claims on behalf of passengers. Passengers get part of what they would be entitled to under the regulations, but it's not the best way to do it. And I will speak about ICAO later, but I want to mention that at the outset, we're going to raise this core principles document at ICAO and the need for this to be updated and the need for them to once again reinforce to member states that this is something that is very important. Consumer regulation really should apply to flights departing an airport in a particular state and not bring in regulations that apply because of other links to that person going forward. And I also want to emphasize that when IATA and ICAO are involved in developing this kind of pure regulatory standard, we don't work with them to develop a template regulation or encourage regulation when one doesn't exist, but it's where regulation is enforced or in development, the principles should set out some basic criteria that should be followed. And I put that in the context as well of other work that we did on regulations with ICAO in recent years, unruly passengers, for example. What we did is we worked with ICAO and we actually developed some guidelines and guidance material for states with them relevant to the airline's expertise in that area. But we didn't mandate particular ways of regulation. Same is going to happen with upcoming work I'm going to talk about on data privacy as well. So I like this slide. Does that get you interested? Mischief managed, what we're talking about here today. It's the rise and rise, as I like to say it, of consumer regulation specifically applied to aviation is more than just a consistency issue. Yes, there are inconsistent regulations, and we'll review some of those later. But it's also about what the objective of consumer regulation is. It's to safeguard the rights and interests of consumers, ensuring fair trade practices, preventing unfair exploitation, and providing some kind of redress if there's a dispute between the provider of a consumer service or product and the purchaser and customer. And consumer rights in the aviation context has taken a kind of divisive way of looking at it. So yes, there is that primary objective of consumer regulation that we all know and expect as a right. And there's also the airline liability issue, or liability issues in general. That is, getting compensation for a loss, which is not quite what consumer regulation is about. Consumer regulation is about that unfair practices. The compensation for a loss in the aviation context is actually the subject of a number of international treaties, such as the Montreal Convention. And I think that one of the things that IATA has found in looking at the way consumer protection, particularly in the area of delays and compensation for delays, has evolved, it is a bit of a confusion of that right for fair practices and actually compensation for a loss that may be governed by an international treaty. Now, we've made some arguments on this in a number of jurisdictions and have had varying degrees of success on that issue, but it's something that it's still very important and very important to uphold the principles of those international agreements by which states are bound. I also want to say that when we talk about this mischief managed kind of concept that I've got, that is consumer regulation actually something that is managing the mischief, meaning the objective to promote fair trade practices in aviation? It's important to recognize that airlines have a very strong motivation to look after their customers and do so. Additional consumer protection compliance regimes do not address any of those problems, particularly if they're focused on liability or compensation for something that is in fact outside the airline's control, and often is, and delays are really what this issue is about. As my colleague Raphael Schwartzman noted in his presentation on Sunday, in Europe, flight delays have continued to increase despite EU 261 regulation. This is because the regulation has no consequences for those responsible for the majority of delays. So the mischief is not managed by consumer regulation, and the objective is not being met. Consumers' rights are not protected. Now, after that, maybe not controversial in this audience, but maybe controversial in some audiences, question about the objective and purpose of consumer protection. I wanted to talk about a few hot spots and the regulations in those areas, and how we see, by hotspots I mean they're on our radar in terms of advocacy from IATA. So EU, I want to start with that, and the famous EU 261, which I've already mentioned, and as we have mentioned many times, I think that it is a bureaucratic nightmare to administer. EU 261 costs airlines 0.5%, no, 0.5%, sorry, that would have been a big mistake, of their entire cost base in administration costs alone. There have been 80 or more judgments of the European Court of Justice related to EU 261 because of all the gaps and gray areas, and I'm sure, and as a lawyer I can say this confidently, the only person who's really benefiting from that are the lawyers, my colleagues, if we are litigating over language in a regulation that is not clear. And so you might say, well, if it's not clear, why isn't it fixed? It's taken a long time to be fixed, but the reform of EU 261 is now on the table, and in fact discussions are going on right now. Chris just looked up some updates on what is being discussed. One of the important things that is under consideration is changes to the delay thresholds that were implemented after one of those court decisions, not as a result of the original regulation. And I think we want to emphasize too, in our discussions with those policymakers that are looking at the reform of 261, we want to emphasize that passengers actually want to get to their destination rather than be focused on a threshold for compensation. They want to get to their destination as soon as possible. So we encourage all those ministers attending the Transport Council to look at increasing the delay thresholds and alleviate some of the financial burden of 261. So Canada. So I'm actually originally Canadian, and we have had some litigation, industry litigation on behalf of our airline members in the last 18 months or so regarding the Canadian APPRs, our Air Passenger Protection Regulations. We were unsuccessful actually in that, and the question in that case was arguing the Montreal Convention liability issue. But that isn't really the end of it, because as often in legal cases, it's down to the fine lines of what was in issue in that case. The CTA, so the Canada Transport Agency, has a backlog of 60,000 cases related to the APPRs. That's not helping anybody. It's certainly not helping the consumers. We are hoping that with reflection and further advocacy, that there will be a relook at the APPRs in the near term. Brazil is a very interesting jurisdiction because it is one where there are claims made under compensation claims under consumer protection, and the figure I have is 79 claims for every 100 flights, and that's compared to 0.01 claims for every 100 flights in the US market. So there's an awful lot of claims, and the reason for that is that there have been mixed decisions, and by claims I mean there are also legal cases pending being decided in Brazil on this issue. And the reason is there is a lack of adoption or actually implementation of Brazil's own obligations under Montreal Convention 1999. And so IATA has been working together with local associations, the authorities, and the judiciary to provide more and more information on the treaties and the international framework that apply. And things have been improving in Brazil. That has brought an improvement. I also want to just say that one of the issues when you're dealing with damages claims as opposed to fines, perhaps, is that insurers are involved in those as well. And so insurers who might want to settle claims because they are relatively minor, makes it even more difficult to have the precedents set in law that would make things better. I realize I'm talking a lot about consumer, but I just protection. I want to keep going on a couple of other hot spots, and that is the Middle East, Oman, and Saudi Arabia. There are new legislation coming through with heavy penalties for airlines in the event of delays, cancellations, and schedule changes. And in some ways, they're even more punitive than EU 261. However, they do have a list of extraordinary circumstances for delay. Australia, they have chosen not to follow EU 261 and rely on general consumer law, which is something that we think is the most appropriate way to deal with these things. And we hope, as we know, there was a recent election in Australia, that will continue. In the US, just to mention that there was a proposed regulatory reform late last year, and we hope that regulatory reform that's being undertaken now will not proceed with those regulations. So I want to move on to data protection, and I promise I won't be as long. So what are we talking about here? Why is this even a regulation we're talking about? I think it's, I want to give it as an example of some success that we've had in getting ICAO to do something about it. It is also something that has very serious cost complications for our members. So it's about transferring data to facilitate the physical transport of passengers and goods across borders. And we all know that happens, and we all think, okay, we're going, we've paid for our ticket, we've actually consented to all of that. But it's not quite so simple as that. Air connectivity requires the data is shared across borders, and it simply can't happen without it. And it has to be shared with other airlines, airports, travel agents, ground handlers, caterers, and airports, and more importantly, the governments themselves who are setting those regulations. And as a result, it causes a lot of compliance risks because the regulations that govern many of our airline members or many of the passengers carried by our airline members don't allow some of the transfers to governments themselves. At the moment, there are about 140 states with some form of data protection law. And the compliance risks are significant, but the compliance costs are probably the more pressing needs to be addressed. So the volume of transactions and complexity of different laws means that there are significant issues. There are significant differences between the laws. Even the way the legal basis for using data is different. In some jurisdictions, consent rules everything, and in some it does not. So the protection that these laws seek to put in place is really compromised. So that the rights that are being protected are compromised because they are inconsistent, they're complex. And there are very extreme practical implications for airline members, and in addition, potential for fines. And the example often given is the requirement, which is actually an ICAO recommended practice, to provide PNR, passenger name record data, and there are in some places fines of up to $50,000 US per flight for not doing it. However, those carriers actually would be in breach of their own data privacy laws, such as the GDPR, and subject to significant fines based on a percentage of their income to their regulator. So it's an impossible situation. I want to move on to ICAO action because this is the success story of this. We raised this issue, this consistency issue with ICAO. We held a joint seminar with ICAO and some other organizations. And after 2 years of effort, the ICAO Council put the issue on the work program of the ICAO Legal Committee, and it didn't just sit there. The Secretariat of ICAO has now started a study group which consists of data privacy, air law facilitation, and other experts from states and industry, including IATA and including the OECD. And that group is having its first meeting this week, 4th to 6th of June in Montreal, and a further meeting planned around the Assembly. We'll be playing a part in this, but the objective of this is actually, the first objective is to get guidelines for states. But the question is whether or not we actually need something even more fundamental to get this issue recognized. And I think what is really important is recognizing that aviation as an industry is different from other industries where there is cross-border transfer, because it's the physical transfer of people with their data as well. So far today I've mentioned ICAO several times, and you probably know a lot about, or have heard a lot about ICAO, and I want to talk about what's coming up. We have the ICAO 42nd Assembly taking place from September to October this year. So you might say, what is the Assembly? Who attends? Why is it important to IATA? Why is it important to our airline members? Why am I talking about it today? We're not ICAO, and I'll explain a little bit about, sometimes people do confuse us with ICAO. But the ICAO Assembly takes place every 3 years, and it's a meeting of all ICAO member states. Those are the signatories to the Chicago Convention, and those that have been added over the years. And yes, it's their governments. They set the framework. ICAO as an organization, sort of like the civil service for the convention, and the states who've signed, sets the framework for safety, security, sustainability, and everything else for aviation, for international aviation. And that's why it's important. What is also important is that the states aren't the only ones that will attend. In addition, other international organizations, when the states attend, they bring with them their diplomats, so there's a lot of diplomatic negotiation, but they bring their CAAs, they bring their regulators, And this year, we think they might bring some of their data privacy regulators. That would be quite interesting. So it's a really important opportunity for the airline sector to not only influence and shape the work of ICAO on issues of importance, but it's also really important to bring issues that are important to the airlines on a wide range of topics that may not yet be on a program of ICAO, and maybe won't be, but it would be important to have it raised with states and have states be aware of it, and also to discuss it with our sister trade associations and other organizations to work together on some of these things. It's a really important advocacy opportunity for IATA. And what is IATA's role? We actually are officially an observer to ICAO, and that is, we're officially an observer. We don't have to ask to be an observer, as some other organizations do. We've been an observer since 1945, and that's sort of because we share the same origin story, which is that at the same time ICAO was formed as the Association of States, IATA was formed as the Association of Airlines, who back in 1945 were mostly owned by states. So it was ICAO for the regulations and IATA for the practical effects and standards that affect airline operations. Even in our Articles of Association, one of our 3 objectives and the purpose of IATA is to cooperate with ICAO. It's spelled right out in our Act of Incorporation and carries through today. So our role with ICAO means that we actually have a lot of gravitas, a lot of what we say gets listened to. Maybe they don't all think that, but I know what happens with our relationship with the Secretariat and our role in ICAO. So sometimes there's a little bit of confusion about what IATA does and what ICAO does, and I think it's important to think about that distinction. ICAO as the governments, the regulations, the standards that apply as a requirement to safety, security, and operational infrastructure, and IATA as the standards setting that are the standards that are practical, important for airline operations. So I was going to perhaps just talk a little bit about what are the hot topics that we want to bring to the attention of all those important people at the Assembly, and I think none of those should really be a surprise. Sustainability and environment has been the biggest topic at ICAO for, I've been going to Assembly on the States side for New Zealand, starting in the late 90s, and that was a topic then, hot topic then, still is. Accessibility, important to our airline members, consumer protection, which we just talked about, radio spectrum, which is something that is, of course, growing interest, and taxation, really important. Not to mention data privacy, but we've already crossed the line on some of that. So the work of ICAO with IATA and its airline members offering airline expert input helps make today's global, interoperable, and safe aviation system the success it is. Aviation is stronger working multilaterally and to global standards. IATA and ICAO work together to make that happen. So thank you very much. I'm happy to have questions, and I apologize for going over time.
Not to worry. Okay, do we have any questions? We have a few minutes, so yes, sir, at the front.
Ranveer Nair from AGM. Question on consumer rights. As a consumer myself, I find that airlines' resistance to compensation of any kind is increasing, and I can talk specifically of instances in India where it's not just surge pricing, it's vulture pricing. Most recently, the attack in Kashmir that led to an exodus of thousands of tourists. And airlines could sell tickets which are more expensive than a two-way flight from here to Paris. has to be some control. Of course, airlines will say that the demand was too much and all that, but ultimately you can't be profiting so much at a time like this, and this is nothing but profiting.
I think that's a different issue than the consumer protection regulations for fair trade practices. I think you're talking about
it's
price.
all about consumers.
You're talking about price controls for and how airlines set prices for tickets, which is a different topic.
Yeah.
But I know it's related to
No,
consumer.
ultimately it impacts the consumers. It doesn't impact anybody else. And we have seen this consistently in India. So I would be very happy if India followed that European regulation.
But the European
I
regulation
know
does
there's
not
a control
have
pricing.
Wouldn't
anything
cover
about
But
price.
at somewhere the consumer must get something.
Yeah.
Here flights get delayed, people are packed inside the aircraft, AC is not on.
Yeah.
You can sit for hours on the tarmac in the blazing sun.
Yeah.
There's
So-
no compensation.
Yeah.
So my suggestion is that we need more protection for consumers than less. And there is a conflict, I understand it. You are running a business, you're not running a charity. But consumers are ultimately paying through nose for what?
Okay, thank you for your point. Itika, just the lady there.
Yes, Iteke de Jong, Daily Telegraph, the Netherlands. A question on, a little bit flavor on how to get on with this threshold of more hours. Why is it that airlines choose now to annul the flight instead of, the claim is if we make the threshold higher, more flights are, more passengers will come at their destination. Could you explain that?
Yeah, so that's essentially the current rule in Europe with the EU 261 is that after 3 hours, compensation is due. So there's usually at that point, the airline will cancel that flight because they're going to have to pay the compensation, and passengers will have to move on to later flights. But the evidence that we're trying to build up, and we don't have the actual numbers, but the evidence looks like there's a large majority of those flights that get cancelled at 3 hours would be able to operate between 3 and 5 hours, because by then you've got the time to find the extra crew or fix the problem on the plane or bring a new plane in, or just the delay because the ATC delay has been so bad and that's sorted itself out. So what we think, what we know from the polling of passengers is that passengers, yeah, of course they don't mind getting compensation, but actually what they really want to do is get to their destination, even if it's better late than never. So the threshold change, and the 5 hours was what was originally kind of conceived of, and as Leslie mentioned, it only became 3 hours later due to legal kind of decisions. So 5 hours was always kind of seen as the appropriate number, and we would like that to be reinstated. Do we have any other questions? Oh yes, lady over there, thank you.
Hi, Forum Gandhi from the Economic Times. I wanted to ask you, what are the specific regulations that you're worried about, especially in India, because you touched upon a few other countries which were your hotspots, but you didn't touch upon India. You also mentioned about the 0.5%. I was wondering if there was a quantification for India as well. Thank you.
I'm sorry, I don't have the specific regulations in India. It's not, at this point, it's not one that we are actively looking at, but I would be very grateful to receive them and look at them. So I don't think we have that 0.5.
That was the European.
That was a European.
It was an administrative cost of EU
Yeah.
261, which if it were applied in other countries would presumably be just as great, and that costs a lot.
Yeah, I was looking for a quantification similarly for India as well, but I understand you're not tracking that. Thank you.
Yeah, I think the point being that with the current Indian regulations are not top of our list of concerns. Otherwise, we would have flagged it. So presumably, India has got a good regime at the moment. Yes, Ian.
you. Yeah, Ian Taylor from Travel Weekly in London. Just on this gentleman's question, there is actually, the government in the UK is looking at the question of surge pricing in relation to event tickets and travel prices at the moment, and possibly incorporating something on that in the regulations, which obviously the industry is alarmed about, because they've also confused kind of drip pricing of adding ancillary things that may, whether they're available or not into that, which is something quite different. But just on the regulation 261 and regulation like it, obviously you want changes to it, and the threshold seems sensible. It would be useful to have clarification on what sorts of things are extraordinary and unavoidable circumstances. That would make sense.
Yeah.
But isn't the reality that this is only going to go in one direction? Because in the end, legislators are going to be looking more at what consumers who elect them are interested in than what the industry wants. Or is the EU's new focus on competitiveness an opportunity for the industry, do you think? And do you think you'll see changes emerge from the current process, or could it just fold like it has done in the past?
Yeah, I think that's a really good question. I think that there is always a tension between in a political setting when you're dealing with consumer regulations, because there is a political element to it. But I do believe that the issues, for example, that Chris has highlighted about consumers want to get to their destination, that makes the threshold change a sensible way of perhaps making that happen more, because decisions will be made on the basis of when those thresholds kick in. So there is always that tension. I think we have optimism for the current revision of 261. It's been something that's been in the cards for a long, long time, and now there does seem to be some discussions. I think it's a ministerial conference that's going on this week, and then the outcome from that will be, I believe, debated further. The IATA team has been involved, along with our other sister trade associations, in discussing those issues with those ministers and their counterparts in Brussels. So I think it is something that we have optimism that a kind of fairer regime that will look after the rights of consumers and also decrease the costs and complexities of the current framework, bring greater clarity to what in fact is something that's delay. I think one of our frustrations is that the delay isn't necessarily resulting from something within the control of the airline, and that is something that is hopefully going to be thought about a bit as well. I think it's something we all face as consumers. Of course, we are all consumers as well. And I'm just thinking in my personal experience in a recent flight into Heathrow that was cancelled because of the fire. I mean, there's a good example of the question raised. How was that delay or cancellation caused, and who should ultimately be responsible? But I won't wax lyrically on that philosophical issue.
Thank you, Leslie. We have a question in the corner.
Hi, just one last question. I don't know whether you would be able to answer it aptly right now with the kind of data that you have. What prevents you from having more bite and more teeth into a kind of a regulation that applies to all the airlines in terms of addressing of the grievances? Aren't we just leaving it to a very cushion kind of a thing when they say that it will be largely governed by the consumer practices that are followed by the same country where the person is originating from?
Yeah, I think, well, that's sort of the big question is, and you might say it's because actually each country's developing their own consumer rights legislation on their own. There are, of course, big examples like EU 261, for instance, and that's where we see the role of ICAO as particularly because the ICAO countries that are meeting in assembly, but meet all the time, have in fact put out a code on consumer regulation, and why we want to remind them of it again. But you know, I also think we need to recognize that in particular regulations that impact people's rights, that of course states want to have control of the rights of their citizens, and I'm just raising that as not a. It shouldn't be. I agree with you though. It shouldn't be the reason that we can't succeed on this. In fact, it is important to recognize that, but to also recognize that other rights, such as the freedom to fly in a fair way and to have data protected fairly as well, it means that we need to think about this on the international stage.
Because if ICAO can do a safety audit, which they really stick to for all countries, I think they can look into some kind of a thing, and US leadership would obviously push that. I really don't want to.
Exactly. So ICAO's standards and recommended practices and the scope and mandate of the Chicago Convention for them to establish them really covers anything aviation. But one of the issues that we had when we first started talking about data privacy with ICAO was the comment that, well, they don't have the expertise because they actually are mostly the civil aviation regulators and security regulators. And so that's why we've had to kind of bring in our expertise, explain to them, and made them recognize that it is something that affects aviation in a very particular way.
Okay, I think we'll go there. We're over time. Thank you very much, Leslie. And if anyone does occur any more questions, just come and find us in the media room, and we'll get back to you on those points. Thank you.
Thank you.